back to Law at Home. This is Attorney Rico Rentuza, and we're still in our series, Land Ownership. The other week, we discussed about the first way or mode by which we can obtain torrents title, and that is by way of ordinary or original or registration proceedings based on Section 14 of PD 1529. Last week, we discussed about the second mode, second way by which we obtain torrents title, and that is by way of administrative proceedings pursuant to patent. And I shared with you Section 103 of PD 1529. Today, we're going to discuss the third way, the third mode by which you obtain torrents title over a parcel of land in the Philippines, and that is through the cadastral proceedings. Before I continue, I'd like to invite you to send your questions. If you have questions, you can type in the comment section or you can send it by way of message through our page. And if you want to help others learn about this topic, kindly tag your friends or family members or share this video or follow our page. And also subscribe to our YouTube channel, Rico Rentuza. Okay, so let's continue. Now, again, cadastral proceedings, another way to obtain torrents title. Now, what's the difference between cadastral proceedings and the ordinary proceedings that we already discussed? Well, before we discuss about the difference, well, the similarity first is that we both go to court. In Section 14, we go to the regional trial court. Also, in the cadastral proceedings, we also go to court. But the difference lies first on as to who initiates the proceedings. In Section 14 of PD 1529, the one who initiates the proceeding is the claimant or the applicant to the original registration of title by filing a petition in the regional trial court and have his title confirmed by the court. In cadastral proceedings, it is the government that initiates the process. And what the claimant or the one claiming ownership over the parcel of land will do is just to file an answer to the petition filed by the government. Okay, that's one. Number two, difference between the ordinary registration and cadastral proceeding is the subject matter of the proceedings. In ordinary proceeding, the subject matter is generally a private land. But in cadastral proceedings, the subject matter could either be a private property or land of the public domain or agricultural land of public domain. The third difference is as to the claim of ownership. In ordinary proceedings, we already discussed that the applicant, of course, is claiming ownership over the subject matter of the petition. But in cadastral proceedings, the government is not claiming ownership over the parcel of land. What the government does is just to provoke, so that to initiate, to provoke those who are claiming title or ownership over the parcels of land to go to court, okay, and file their answer and prove their claim over the parcel of land. Now, the third difference is as to the survey. Now, in ordinary proceedings, it is the claimant, okay, who looks for a surveyor or a geodetic engineer to have the land surveyed. But in cadastral proceedings, it is the government that conducts the survey, and it will just advance the expenses, okay, for the survey. Finally, the last difference is the risk of proving ownership. In ordinary registration, if the claimant fails to prove by sufficient evidence his claim of ownership over the parcel of land, it's okay because the decision in the ordinary proceedings is generally without prejudice, meaning he can still file it after he shall have obtained the required evidence. But in cadastral proceedings, once the claimant fails to prove his claim, it will become res judicata, meaning the decision will now be final as to his claim of ownership. So therefore, if he fails to prove his claim there, the property, the land that is the subject matter of the cadastral proceedings, will now be declared as land of public domain. So therefore, you have now an idea about the cadastral proceedings. So the purpose of cadastral proceedings is so as the government can pressure or can force, in a way, those claiming ownership over parcels of land to bring their case in court. That's why the cadastral proceedings is one that is compulsory on the part of the claimants for them to go to court. Because in the ordinary proceedings, the claimant has no pressure, has no compulsion of filing the application. Okay? So the purpose of the cadastral proceedings is so that all claims over a parcel of land will be settled and adjudicated para wala ng question ang pagmamayari ng mga property. And the government is also interested in having this so that, well, for practical purpose, so that the government can get taxes out of these properties that are now claimed by private individuals, among other reasons. Okay, so the purpose is so that the claims over a parcel of land will be settled and adjudicated by way of compulsion, in a way, because once the government initiates through cadastral proceedings, all claimants are forced to file their answer. Otherwise, their claims will be considered waived. So what is the procedure in cadastral proceedings? So generally, this is the flow. And you will find this, if you want to look at the legal basis in cadastral proceedings, you read sections 35, 36, 37, and 38 of PD 1529. These provisions lay down the procedure in cadastral proceedings. So generally, the first step is the cadastral survey. Now, what is the cadastral survey? Again, just like the ordinary proceedings, cadastral survey is for the purpose of determining exactly the parcel of land, okay, that is being claimed, okay, by certain individuals. And the cadastral survey will now place monuments along or around the boundaries of properties, of the properties that are the subject of the cadastral survey. And this is the time also that the parcels of land that are covered by the cadastral survey will now be assigned with cadastral lot numbers. Before the cadastral survey is made, the Director of Lands will have to send out notices to the general public, okay, by way of posting in conspicuous places in the location itself where the property that's subject of the survey, and maybe posting in the public offices in the municipal building, if it is a municipality, or in the city building, in the city, if it is in the city. So there has to be notice to the public that cadastral survey will have to be conducted. Aside from posting, the Director of Lands will also have to have the notices of the cadastral survey be published in the official gazette, because again, that is the official publication, or where notices and announcements by the government are published, and it will have an official effect when it's published in the official gazette. Okay, so that's the first, cadastral survey. Second, once the cadastral survey is done, the government, again through the Director of Lands, represented by the Solicitor General, will have to file a petition to initiate the cadastral proceedings. It will file a petition in the Regional Trial Court. And the petition will have to state that it is for the public interest that all claims of ownership over that parcel of land that is subject of the cadastral survey will have to be settled and adjudicated. Okay? So, filing of the petition in court. Then, the third process, once the petition is filed by the Director of Lands, through the Solicitor General, the notice of the initial hearing will have to be published. Again, it has to be published in the official gazette and in a newspaper of general circulation. It is similar to the ordinary proceedings. The purpose, again, is to give notice to everyone. And if the claimants are identified, the notice of hearing, of the initial hearing, will also have to be mailed to the addresses of the claimants over the parcel of land subject matter of the cadastral proceedings. So after the posting or publication of the notice of initial hearing, the claimants, those claiming ownership over of certain parcels within the property that is a subject matter of the cadastral proceedings, will have to file their answer. And the answer should contain the following information. First is the age of the claimant. Second, the cadastral number of the lot that is being claimed, or the block or lot numbers, if any. Then the name of the barangay and the municipality where the property, or the city where the property is situated. Then fourth is the names of the owners that is of the adjoining properties of the property that is being claimed by the person filing the answer. Fifth, if the claimant is in possession of the parcel of land that he is claiming, he will have to state the reason or the basis of his possession. Or probably if he's in possession, is based also of the possession of some predecessors, he will have to state the reason of the basis of the possession of his predecessors and the mode of acquisition by his predecessors and even himself, who is the claimant of the property. And the sixth, if the claimant is not in possession, what is his legal basis? What is the mode of acquisition of the claimant? Why is he claiming ownership over that parcel of land? The seventh important information that he has to state in the answer is if the lot, the parcel of land, is previously declared for taxation purposes, the assessed value of the property. Okay? So these are the important information or the details that should be found in the answer. And then once the answer is filed, then the hearing will ensue. And of course, the government will, of course, is the initiator of the petition. It will have to present its evidence, the cadastral survey, but it's really up for the person filing the answer, the claimant, to prove his claim. So in effect, the answer of the claimant is similar to the petition in the ordinary proceedings, where he proves his right, where he presents evidence of his title to the parcel of land that he is claiming. If he is able to prove his right over the parcel of land, then the court will award to him that parcel that he is claiming. Otherwise, if not, then the court will declare that the property will remain land of the public domain. So meaning after the hearing, there will be a decision by the court whether to grant to award the parcel of land based on the answer of the claimant. By the way, there might be two or more claimants in one cadastral proceedings. All right? So once this claimant or claimants prove the right, then again in a decision, the court will award that portion that they're claiming to them. Okay? Otherwise, the decision might be rendered again that the parcel that is covered by the cadastral survey will remain as land of the public domain. And again, as I mentioned, this decision, if it is favorable to the claimant, well, of course, that will also be res judicata, meaning that will be a final adjudication in his favor. So in short, after the hearing, there will be a decision that will be rendered by the court, whether to award the parcel of land claimed by the person who filed the answer, if he proves he's right, then it will be awarded to him. Otherwise, if he could not prove he's right, then the decision will state that the parcel of land will remain as land of the public domain, and that is res judicata. So that's the risk in cadastral proceedings as far as the claimant is concerned. So once the decision is made, then there will be an issuance of the decree and the certificate of title. So this is similar to the ordinary proceedings. So after the decision, once it becomes final, then the court will issue a decree in favor of either the claimant or in favor of the government, as the case may be. Okay, and once the decree is there, it will be forwarded to the registry of deeds, where the decree will be transcribed and recorded, and the court will issue also the original certificate of title in favor either of the claimant who proves his right or to the government, stating that the parcel of land is still part of the public domain. All right? So, on this title now is also the torrens title based on or pursuant to cadastral proceedings. All right? So now we have 3 modes already to review obtaining torrens title: the ordinary registration proceedings under Section 14 of PD 1529, the administrative proceedings by way or pursuant to patent under Section 103 of PD 1529, and the cadastral proceedings under Sections 35, 36, 37, 38 of PD 1529. So thank you so much for joining me here. Next episode, we're going to discuss about the effects or the value of having this torrens title, whether whatever is the mode of acquiring them. Once you have this torrens title, what value has it to you as the holder of the title? Okay? So again, thank you so much for joining me. Again, don't forget, you can send me your questions either by typing on the comment section or sending a message to our page, and help me share to others this information by tagging your friends or family members, sharing this video or following our page, and subscribing to our YouTube channel, Rico Rentusa. Again, this is Attorney Rico Rentusa saying, stay at home, stay safe, and stay out of legal trouble.